What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hey, welcome back to the Lead Counsel Podcast. I'm here with Craig Goldenfarb. This is his second time on the show. What's going on, Craig? How are you?
Good morning, Tom. I'm wonderful.
Awesome. Thank you for coming on. I had sent an email to Craig when the tort reform law passed in Florida, and I really wanted to get him on as a mover and shaker down in Florida personal injury. I thought he'd be a great guest to talk about, what is going on in Florida? How did his firm prepare for it leading up to it once it was announced? And I know Craig and I have been talking about this for years. So, Craig, thanks for coming on, buddy. I'm looking forward to get into this with you. And I believe the tort reform statute, for those of the listeners that are in Florida, is HB 837, right?
I think that's right. And it was effective, I believe, in March of this year in 2023.
Yeah, it was signed into law by DeSantis. So what I figured is take us through what the key components are that you're, aware of, and then we'll kind of just go from there.
Sure. There's a lot of parts about this that are problematic. But what's funny is I remember a quote from DeSantis, which basically, he's like, "Make America Florida." That's like one of his campaign slogans. So
awesome.
Even worse, in the tort reform area, he said, "Make Florida Texas." Make Florida Texas. So it's funny is I have some friends in Texas and they looked at the Florida tort reform and they're like, "Oh my gosh, that's exactly what we have." So what apparently happened is the insurance industry just copied the playbook from their Texas positioning, which all passed under their conservative legislature, and copied it in Florida. And guess what? It worked.
Yeah, which is scary. So for the listeners who are not familiar with the term tort reform, lay it out for us.
Sure. Tort reform is an insurance company bailout. And basically what tort reform is, it's convincing the public that insurance premiums are high because of all these crazy ambulance chasing shark lawyers, and that we're victimizing the insurance company. Now, what's funny is that nobody ever thought, "Oh, poor." Have you ever thought to yourself, "Oh, poor insurance company, they're victims"? No, nobody really ever thinks that. But the insurance company companies and the industry has done such a great job in publicizing alleged frivolous lawsuits and making us lawyers look bad, that they've really succeeded in convincing the public that, the McDonald's hot coffee case and that there's a crazy lawsuit system that's like a lottery. And that is the public perception across the United States. And so in that backdrop, they've succeeded in many states in the United States in getting what they call past tort reform, which is basically insurance company bailouts.
Right. And, it's funny because, we can just dive in the conversation. It couldn't be farther from the truth, right? Like without the personal injury attorneys, use famous examples of the movies, even Erin Brockovich, right? Without the tort attorneys, who's protecting the general public? So it's kind of a sickening stance where I know it happened in California. They put I think it's $1 million cap on med mal. And then you read about a baby born brain dead and how that family can only recover $1 million for the medical negligence, right? So it's sickening, not just because I'm a plaintiff's attorney, but to hear the rationale behind it. The insurance companies, the woe is me, right? So specifically, I know there's specific parts of this statute that really were damaging, right? Reducing the statute of limitations. Talk about that for a second.
Sure. There were about 5 parts of the Florida statute that I wanted to address, and each of them is pretty important. So the very first is it cut our statute of limitations in half. So statute of limitations, for those who don't know, is the time period by which you must file a lawsuit to preserve your claim, because it starts out just as an insurance claim. So in Florida, it used to be that you have 4 years from the date of a car accident, for instance, to file a lawsuit to preserve it if you have to file a lawsuit. And it got shrunk by the new law to 2 years. So what this does is it clogs up the court system too much, because some people aren't done with their medical treatment in 2 years. So you kind of would still like to settle it as an insurance claim. So what this does is it clogs the courts. It forces the use of defense lawyers that are already overworked. It forces us to file a lawsuit too quickly. And then, of course, in Florida, then Judge DeSantis is then reducing the allocation of state monies that go to the court system. So he's clogging the court system and then taking money away from it and consolidating the districts in Florida. It's like he's hitting it from both ends. So the statute of limitations robs people of rights, and it makes people file a lawsuit too quickly, clogs the courts, and then he defunds the courts in order to rob the power from the judicial branch in Florida. So that's the first of 5 parts of the law, which is reducing the statute of limitations. So anything else on the SOL, Tom, or you want me to move on?
Well, so really quick, just so we could be very clear, I have a little bit of experience with that reduced budgeting. We saw that at COVID, where at the time it was Governor Cuomo who they didn't re-up the judges because of budgetary constraints. And I saw what it did to the litigation timelines in the cases that were currently pending in court. It was so damaging. And you know what they say, justice delayed is justice denied. And I think that you're going to see that if you haven't already, because we're seeing it. It went from 18 to 24 months you could get to a jury, to some of our cases are now 5 and 6 years. So yeah, it's very damaging, very damaging.
It's horrible. And what's interesting is that the reason they do that is because they're earning interest on their billions of dollars over at the insurance company. And if they can stop a case from resolving in 1 to 2 years and make it 5 or 6 years, think of the trillions of dollars they have and how much more interest and investment income that the insurance behemoth is earning by delaying things.
Yep. And it's tragic for the, again, listen, we know there's a spectrum of injury cases. But if you think about the catastrophic injury cases that are in your office, and I know you have a sector of critical cases in your office, it's tragic that these families have to wait that long.
It's tragic in a case, especially where a child needs continued medical treatment. For example, a case of a brain-damaged baby, for instance, or someone who has a catastrophic injury, and they're waiting on a recovery from an insurance company in order to pay for necessary medical care. If you have to wait for 5 or 6 years, and your 1-year-old needs occupational therapy, mental therapy, and you have from a brain damage at birth, and you need that money to pay, and you have to wait till the child is 6, that's too late.
Yeah. Listen, I had a brain damaged client that was basically sleeping on his best friend's couch because he could not afford to live, couldn't work. So yeah, it's the same type of thing, and it's very tragic. Take me through the next big component of what passed in Florida.
Sure. One of them that's somewhat confusing to those of us who aren't lawyers is a really restriction on bad faith. And bad faith, the way I describe it, is it makes insurance companies do what they're supposed to do in good faith. So what that means is if they have a certain amount of coverage on a car accident, that's like, let's say they have $25,000 in coverage and my client was killed in the car accident. Good faith requires them to fork up that $25,000 quickly, or else there's a potential that we could recover more than the $25,000 if they don't do it right. What that does is that puts some pressure on insurance companies to do the right thing and pay the limits when a case is clearly worth more than the limits of hypothetically $25,000. Bad faith allows us to get more than that money if they screw up. What happened in Florida is that they really gave insurance companies a gift, which is really give them protections from getting a verdict or judgment above the policy limits. And therefore, it causes them to further delay and deny claims without any financial repercussions. So in that hypothetical case where someone's dead and they have 25 in limits, they can wait a while and hold on to their money and play around with me as an attorney and then tender the $25,000 or pay the $25,000 when they feel like it. And that's not good because insurance companies don't do things out of the goodness of their heart. They only do things that are right if they're pressured financially. So the second part of this law that's awful is they really gave the insurance companies gifts by limiting bad faith exposure.
Specifically, just give me a little bit more on that, because I'm very familiar with bad faith. New York actually had a verdict come down on bad faith several years ago. Case was known as Tavares, but it actually gave teeth back, where it said, hey, listen, the Fair Claims Practices Act in New York, and so there might have been corollary statutes down there, but basically there was a several $1 million verdict in a case that they could have settled for $100,000, right? Tendering of the policy. So what specifically did the statute do with regard to the ability to take a bad faith verdict against a carrier?
It basically gave the insurance companies a safe harbor window of time. So I believe it's 90 days after we file a lawsuit. So pre-suit, in other words, before we file the lawsuit, there is no bad faith anymore. So if I have a client who's killed and there's 25 in coverage, I have to file a lawsuit, and then there's a 90-day safe harbor open window for the insurance company to go, okay, they're serious. We better pay the $25,000, and we're safe now. And all I can get in that case is $25,000. So we call that a safe harbor provision. It's 90 days. It allows the insurance company to wake up and protect themselves by simply paying the money they should have paid long ago. So that safe harbor 90-day window is really pretty pathetic, because they probably should have paid the money before the lawsuit. And it forces us to file a lawsuit to even start the time ticking.
Right. So, okay. So next key component, you said there were 5. This would be number 3. What's the next key component?
Number 3 is what we're allowed to show the jury as far as medical bills. So it used to be that if we had $100,000 in medical bills incurred in an accident, we could show the jury, hey, we have $100,000 that you should give to my client to repay my client. And one of the reasons we do that is we also have the jury reason or some context with which to give us future medical bills for the client after the trial that they need. So what the law changed is that all we can show to the jury is what health insurance may have paid for those medical bills. So we all know about health insurance. They pay, 10% of what a bill is? So if there's $100,000 in bills, we can only show to the jury $10,000 in bills. So the jury thinks that the client's medical care only costs $10,000, and that's really going to affect what they might give the client for the future. So if my client's going to live 50 more years, and the jury hears that they only had $10,000 in bills, they may give a very small amount to the client for the future medical bills based on that 10 number, when in fact it was 100. It was 100,000. So the client's going to need a lot more. So it's kind of a fraud, because we don't know if that client's going to continue to have health insurance after the trial. We don't know if Medicare is going to still exist or Medicaid's going to still exist in the future. So the jury should really be giving the full amount of medical bills, not just what health insurance paid. So what you can show a jury has been severely limited. And again, why? Because the insurance companies want to save money. And they don't want to pay, so that we're really showing it's a fraud that is now being shown to the jury that it's only $10,000 instead of $100,000. So that's kind of complex, but it really affects what they're going to offer to settle cases, because they know that the jury's not going to be able to see big numbers.
Right. And it's also damaging to the extent, like I've always said, look, those past medical expenses also speak to the severity of the injuries and the damages. So you're only allowed to show them 1/10 of what was paid out on that, that example you gave. And it's not accurate. $100,000 in bills is $100,000 in bills. You can differentiate it for a jury. They'll understand, hey, health insurance only paid out $10,000, but there was a clear underwriting current as far as who was driving this. And clearly it was the money from the insurance companies to the people that were behind the passage of the bill.
Yeah, what's fascinating, just to back up with what we were talking about earlier, is that, the forces behind this is that what us lawyers wanted in the bill and what the public wanted in this law was that if we were going to give them this gift, we wanted a premium reduction schedule guaranteed by the insurance companies. In other words, if we're going to save you this much money, insurance companies, we want you to reduce your premiums by 10% per year for 2 years. So that would save all the policy premium paying people in Florida money, which is what the insurance companies were arguing. Your premiums are so high because of all these lawsuits. Yet they wouldn't agree to guarantee us premium reduction. And if you read anything in the newspapers in Florida, premiums have actually gone up since this law was passed. Up, not.
There should be outrage throughout Florida, right? The general public is going to pay the price, as they often do when it comes to big money corporations and, all hidden behind the agenda of the insurance companies that they're putting out publicly.
I call it propaganda because it is propaganda.
It is propaganda. I wasn't using that word, but yeah, it's 100% propaganda. What was the next element? What was the next element?
The fourth one is what we call comparative negligence. Laws were changed. So let me give an easy example, which is, let's say there's a car accident, and it's not clear in some car accidents who was at fault, right? So typical case like this is my client will turn left in front of, taking a left at a light, right? And then a speeding car comes and hits me on the passenger side. So if you can imagine that scenario, it's a very common scenario. Yes. It's called a left turn in front. So definitely my client might be at fault partially for turning left in front of a vehicle, yes. But the car that was speeding, let's say they were going 90 miles an hour, if they were speeding, they may be able to have avoided this accident by either swerving or not going so fast. So that's a very typical case of where both parties are at fault. And it used to be in Florida, that if my client was 75% at fault, then we could get 25% of the damages awarded at trial.
Right.
And that's probably how it should be, which is that whatever percentage my client is at fault should be taken away from the damages. What Florida did is make Florida Texas, right? So what we did is we passed a law in March, Governor DeSantis signed it, making a 50% threshold, which means that if my client is 50% or more at fault for an accident, my client gets nothing. So let me give that hypothetical again. My client turns left in front and the speeding car hits it, and the jury finds that my client was 51, and my client's killed. And my client is 51% responsible. That's what a jury finds. Guess what the surviving widow gets in Florida now? The answer is zero. Zero money, because my client was 51% at fault or more. So some states have that, which is a 50-50 threshold, but the better states do not have such a threshold. So that's a typical example in a car accident scenario. The other is a slip and fall. And in North Carolina, they have it so it's strict liability, so that if the client is at fault at all for not seeing the banana peel or whatever they slipped on, they get zero. In Florida, it's now at least a little better than that. It is 50-50. Right. So if you didn't see what you slipped on and the jury finds that it's 50% more your fault for not watching where you were going, you get zero. So if you slip and fall on a substance at a grocery store and you hit your head and you have concussion or brain damage or even die, and the jury finds that you should have seen what you slipped and fell on, 51% or more, you get zero.
Which it's just, you mentioned North Carolina, because I talk to Herb all the time. That's across the board on all of his cases.
Wow.
1%, you're out. And it's just unbelievable to me. I mean, that is an archaic notion. And the fact that they're moving in that direction really does speak volumes about what they think about the general public and the rights of the general public. It's crazy to me.
It's horrible. And insurance companies can convince a jury almost always that my client, has some responsibility for what happened. They always can, and even 1%. But in Florida, it's a little better than North Carolina. It's 50%. But still, they're very successful at arguing, especially in slip and falls, that my client should have seen whatever they fell on. And a jury usually does buy that argument that the person does have some responsibility to look where they're going.
Yeah. So as you're digging into this, now I'm seeing why there was such a big uproar. So tell me the last facet.
There are many other facets, but the one that I chose to pick as my top 5 insurance company bailouts is the removal of attorney's fees in first-party cases. So let me break that down. So what happens in many cases, especially where you have to bring a case against your homeowner's policy. So let me give you for example. So you have a hurricane. We have lots of those in Florida. I hear you got one in New York recently. But so you have a hurricane and your roof gets damaged, and it costs $100,000 to repair your roof. So the insurance company gets the estimate, and of course they say, no, we're not paying. So you have to get a lawyer for your $100,000 roof claim. The old law was that if and when you win, because you will, because you need your roof, right? So if and when you win, your lawyer is paid by the hour by the insurance company. so that it really doesn't cost the client anything because they get the check for their $100,000 for their roof, and their lawyer is paid for by the insurance company. That's the old law. So Governor DeSantis in the insurance company bailout decided that's no good. We don't want insurance companies to have to pay extra for fighting. So what they did is they stripped out the law and got rid of it that makes the insurance company pay. It's a loser pays. It used to be a loser pays, right? The insurance company's the loser, they pay the lawyer, the plaintiff's lawyer. Now what it is it's forcing the lawyers to sign on a contingency, which means that the lawyer gets a percentage of what is recovered. So let's take the same case. $100,000 roof damage, you have to pay your lawyer 40%.
Right.
So now when the insurance company writes a check for $100,000, the client gets $60,000 instead of $100,000. So you've got a $100,000 roof repaired, yet you only got $60,000.
Right.
Who's going to hire a lawyer?
Right.
So there's no recourse because why would you hire a lawyer? You're only going to get a check for 60% of what you need. So it's really hard now for lawyers to take these cases because you need $100,000 for your roof. You don't need $60,000 for your roof. So they took the bite out of the law so that lawyers will have to leave this area of law and people are going to have to do it themselves. Good luck fighting an insurance company yourself.
Yeah, no, that's a brutal, what's becoming clear is this was really well thought out, right? Really well thought out. And it's really damaging to the public. So they said, listen, we're going to change the fee structure for these bad attorneys that are getting paid hourly when they're successful, by the way. And we're going to make it so nobody hires these attorneys anymore. It doesn't make sense, right?
It's true.
It's crazy.
And the same thing happened in the audit. It was the same law that applied to automobile cases when you have to sue your own car insurance company for not paying your medical bills, which I know you do, Tom, no
Yes.
coverage. So You were in Florida, Tom, and you did your practice, which is no fault, suing the Geico or Progressive or Allstate for not paying medical bills after a car accident. Your practice would be dead.
Yes. Yeah, and, we talked about that because there was a point when I was contemplating opening up a Florida PIP unit. So question, leading up to the statute, and I know you've been following it for years. So from a business perspective, had you begun preparations for this way earlier than the announcement? And, I believe there was a mad rush once the announcement was made as far as what direction they were going in. So what did you do to prepare leading up to it? What did you do once you knew it was going into effect?
Well, I called my friend Tom Tona and I said, "I'm not going to business yet, buddy."
Right, you did do that
on the PIP firm. So that was the thing is I knew enough not to get you into a bad situation,
and thank you for that.
But as far as the slip and fall, so I tend to be different than other lawyers. So when other lawyers run away, I run to something. So I double down on my slip and falls because we're really good here as lawyers, and we can make sure that we can theme a slip and fall case so that the jury will not find my client more than 50% responsible. So we're good at theming. And if you're good trial lawyers and good litigators, you can think up ways to make sure that the jury understands that it's really more of a store's responsibility to keep their floors clean than it is for a person to be looking at their feet while they're walking through a grocery store. So on slip and falls, on the comparative, we did not change our business practice. And we discussed it. And so now we are marketing for more slip and falls. So this didn't kill slip and falls. It made it more challenging, but our law firm's up to the challenge. So that's what we did on the comparative negligence. We never did any of those roofing claims and the first party claims. We never did that area of practice. And one of the reasons I never got into that area of practice was because I knew that the insurance industry had that law in the crosshairs to the attorney's fee shifting provision. So I made a business decision never to go into first party coverage. And so therefore I don't do any roofing claims or homeowners claims. On the medical bills issue, which is what you can board at trial, we are figuring out other ways to show a jury how severe our client's injuries are. And even though the medical bills amounts that we can show to a jury are less, we're just figuring out ways to make sure a jury understands the severity in other ways.
Like life care plans and stuff like that.
Future life care plans that do show the real numbers. So we're allowed to put the real numbers in a life care plan. Yep. As far as the statute of limitations, we have had to change our business structure a little bit. And we're hiring an extra couple of litigators, lawyers, because more cases are going into the court system quicker. So the way I planned for that was just to staff up a little heavier in my litigation department, which is my trial lawyers. So that's to handle the fact that we have to file lawsuits quicker. So that's some of the long-term planning we did.
Have you seen a cooling effect already in terms of claims or the industry or smaller firms in your area being impacted by it? Like your firm is very sizable. I don't forget how many people you're up to now. What are you up to, like 75 people?
We're at 80.
80. So you've got a little more bandwidth and that bandwidth gives you some measure of protection. Have you seen smaller firms being impacted, solos being impacted by this change where they can't do certain things that you can do because of your scale?
Yeah, I think two things have happened. The first is that some smaller guys, well, first of all the PIP lawyers who do what you do have gone out of business. They're having to start to be a competitor of mine, and they're doing more personal injury. So their first party practice, which is, suing homeowners, insurance companies, and doing PIP suits, that's pretty much dead, because people won't hire a lawyer for that roofing claim, and PIP suits are dead. So those lawyers are now coming into my space. So there's more competition. The smaller firms, some of them are going out of business because they can't handle the slip and falls anymore. So luckily they're sending them to me, I hope, but the numbers are less and the settlement offers are less. So the insurance companies are becoming more brave in two ways. One is that they're reducing the amount of the offers. That's the first way that insurance companies are becoming emboldened by this. So they're offering us less money, which then forces it to go into the litigation system, which has to be occurring anyway quicker because it's now 2 years. And the third is that we're trying more cases. And the reason we have to try more cases is because the insurance companies want to find out how these new laws are going to play out with juries. So whatever medical bills can be shown to a jury, we want to see how that plays out. And what's happening with the 50-50 split. Where are juries leaning as far as slip and falls? Are they really finding plaintiffs at fault? And if that occurs and they get the data, they're going to start to offer a lot less money on slip and falls too. So that's going to force more slip and falls to trial. So all in all, it's going to clog up the court system, which again then has been defunded by the Florida legislature. So it's just a cavalcade of garbage that has been brought down by the legislature.
Right. So real quick, I kind of threw this in at the last minute, but I'm fascinated lately by the topic of nuclear verdicts because that's another justification a lot of tort reform flag bearers will use is these nuclear verdicts, right? You're familiar with that term, obviously, correct?
I think you're referring to verdicts like the McDonald's hot coffee case or something like that.
Right. So where they'll budget or offer $100,000 or nothing and then get hit with a $10 million verdict. Anything that's a huge surprise to the insurance carrier.
Right.
But I forwarded you a report. I don't know if you read it. It's by the Defense Research Institute.
I do. I have it printed out here, but I didn't get a chance to read it.
Okay. But basically it's written by a major defense attorney. And what I found brilliant about it is he's like, look, it's basically our fault if there's a nuclear verdict. He's basically saying properly adjusting claims fairly and early on eliminate these nuclear verdicts. And I just wanted to make this the ending of the show, which is this. What they're doing is so unfair to the general public. And then they're making it like we're the bad guy. And then I had a gentleman on LinkedIn who was a defense attorney, because I talk a lot about nuclear verdicts lately. And a defense gentleman say, why is nobody talking about the plaintiff's lawyers and the juries? And somebody else chimed in, because I wasn't going to get in a fight with the guy, but somebody else chimed in and said, are you blaming juries for returning verdicts that they're tasked to come back with a verdict? And you know Ryan McKean, right? You know his $107 million verdict?
Of course.
Okay. So Ryan's case is the perfect example. They could have settled that case for $26 million, which is all the coverage they said they had, but they weren't taking a dime less. They forced it to trial with a $2 million offer. Mind you, the guy's spine was severed. He's in a wheelchair the rest of his life. And the jury comes back with a $107 million verdict. How could you fault the jury? How can you fault the plaintiff's firm, right? And the defense attorney's comment was, well, with all of the trial tactics, he's referring to Reptile and the Reptile Keenan Trial Institute stuff, and the propaganda of the plaintiff's firms.
Wow.
And so basically these true believers are drinking the Kool-Aid There's a stark warning, though, that my old mentor, Don Sullivan, used to say. He was a big trial guy, which is we're all on the same boat, defense attorneys and plaintiffs' attorneys. And where plaintiffs' counsel goes, defense is on the other side of that boat, just waiting. So if they're looking to sink defense firms, guess what? If they're looking to sink plaintiffs' firms and eliminate this whole show as they would, where do the defense attorneys think they're going?
Yeah, it's crazy. I mean, it's a symbiotic relationship that if we go away, they go. The defense attorney industry goes away too. So the ones who've sort of drank the insurance company Kool-Aid that plaintiffs' attorneys should be ruined, or they're getting rid of their own job. It's a yin and yang system, which makes sense because there needs to be lawyers on both sides of every case.
Checks and balances, right?
Which is why our system, in my opinion, is great. You know, I've been to other countries where I learned about other court systems where it's heavily weighted in favor of one side or the other, and it just doesn't make any sense. I mean, our system is not perfect, but in studying others, it's really the best we can hope for, which is a fair adversarial system. And if the defense attorneys, it's, you know what it's like? It's like complaining after you lose a football game, the other team was too good. That's not fair. So the defense attorney is basically saying, why aren't we blaming the team that's too good? Why aren't we blaming the plaintiff's attorney who has all these secrets and skills and training psychologically? Why aren't we blaming that guy? That's like saying, you know, Tom Brady's too good. He shouldn't be allowed to play football. That's not fair. That's ridiculous. And then also blaming the referees, which is the jury, for basically doing their best, listening to all the evidence. And that's why we have a Sixth Amendment, which is the right to a trial by jury of your peers. So the Sixth Amendment says whatever those jurors decide is the decision. It's your peers in the community. And so this defense attorney you're talking about, Tom, is basically saying, Tom Brady's too good and the refs were bad, so we shouldn't have lost. And that's not right. That's not how you treat a competition. It's you got to rise to the level of the competition and don't blame the refs and don't blame the other side for being too good.
Right. And it speaks to, there's a lot of talk going on in the plaintiff community. Like I'm attending Ryan's $100 million day. There's a lot of talk in the plaintiffs community right now that because we're all sharing, like the carriers do, it's no longer adversarial like, oh, it's me versus Craig or me versus Ryan. No, we're all on the same side, right? So because there's so much sharing going on, you know, there's a lot of talk that the pendulum is swinging for plaintiffs in that direction because of the lawyers that are stepping up and willing to try cases and take verdicts.
Yeah, there's a lot of collaboration on our side because we have a common foe. And the common foe is the insurance industry, who has a lot more money than we do and a lot more lobbyist money, a lot more propaganda and advertising money than we do. I mean, just watch TV. You'll see a lot more commercials for Geico, State Farm, Progressive, Allstate than you will for plaintiffs' attorneys. They have a lot more money and they're a lot more organized in the country on a national level. So for them to complain that we're sharing information with each other and that we're skillful is hilarious. I mean, it's just ridiculous that they've convinced the jury that insurance companies are victims. I mean, I just go back to what I said at the beginning. When's the last time you felt that your insurance company deserves sympathy?
Right. As they raise up your premiums 10 to 15% a year, et cetera.
It's amazing to me that one of the first things we hear from clients when we tell them they need to file a portion of their claim against their own insurance company, like for medical bills or for uninsured motorist coverage, the first thing they say is, oh, I don't want to do that to State Farm. They've been my insurance company for 20 years. As if State Farm is delivering them birthday presents and gifts. And therefore they owe State Farm, their good neighbor, a duty to save them money. I'm like, are you kidding? You've been paying State Farm premiums for 20 years and now you feel guilty about making a claim?
Right. And they don't want to pay you. And they will do everything to not pay you.
It's like State Farm's my friend. Are you kidding me just because they got a nice commercial?
That's exactly it. You just hit it on the head and we'll just kind of tie it up like that. That's what that attorney was saying is basically the plaintiff's bar's propaganda is so strong it needs to be examined. And I was like, are you kidding me? For the decades, probably 30 or 40 years that the insurance industry has been putting out commercials about insurance fraud and how bad plaintiffs' lawyers are.
I mean, there's some of my favorite commercials. I mean, the guy, Allstate Mayhem guy, the black guy for Allstate with the deep voice, the Geico lizard, the Geico caveman, I mean, Progressive Flow. I mean, think about some of your favorite commercials during the Super Bowl or during anything you watch. the don't turn into your parents Geico thing that's going on now. It's hilarious. It's some of the best TV commercials that there are. And why do they do that? Why do they spend so much money and have such great commercials? Because they want people to actually feel good about insurance companies. It's brilliant. I watch those commercials and I'm like, those are funny. They're really good. I still hate insurance companies, but those are really good. I like Mayhem. He's a hell of a character. He's funny as hell. But they're doing that brilliantly to convince the public that insurance companies are good.
So really quick, on that note, I'm sure you've had the same thing. I've had the experience where insurance adjusters are clients because they know my firm, we're in the industry, and you get a different picture when all of a sudden it's your husband that was in an accident, you're referring him over to the plaintiff's firm. Have you had that experience?
We have. It's kind of funny. I've heard a saying before, you never like plaintiff's lawyers or policemen until you need one.
There you go.
And a lot of people don't like policemen, but when you get robbed, you're going to like the policeman that reports to you to talk to you about how you got robbed or mugged. And when you get hurt, whether you're an insurance adjuster or some plain normal person, you're going to like your lawyer. And all of a sudden, you're going to see that a lawyer has value. So you never want a cop. You never like cops or lawyers until you need one. And that's what's unfortunate. I have represented insurance adjusters. And as soon as their neck starts hurting or their back starts hurting, you realize it's not all BS. It's true.
Right.
And the claims aren't all fraudulent.
And those are the ones that are like, I need the policy. Don't come back to me with anything but less than the policy.
They're the toughest, even though they're the ones denying claims all day.
Yeah, exactly. So on that note, for anybody that's listening too, if you really want to find out what's going on, inner workings behind some of the biggest carriers, go on Reddit and put in the search bar, let's say Geico. There is a subreddit that is the inner workings of every employee of Geico and what's going on over there. So I just did everybody a favor. If they have not done that, go down that rabbit hole. Craig, thank you so much for coming on and sharing about this. I was very curious to see what's going on. I'm very nervous to see that if this is going to end up on the Republican agenda overall, and if there's a success, at the presidential level, what could that mean if that's on their agenda? I know it's always talked about, but every 4 to 8 years, it kind of has fallen by the wayside, and I really wonder if it's picking up steam now.
Well, I hope not, and God forbid if we make America Florida. I hope not, as far as lawsuit reform. And so, keep DeSantis out of office, but I don't think he's going to win anyway. Trump, for some interesting reason, Trump does not have that as part of his major agenda. DeSantis does, so I don't. I'm a Democrat, but regardless, this is more dangerous than Trump in that particular area.
Yeah. All right. Listen, man, thanks again for coming on, and I'd love to have you on again. You're the best, man, and I'll see you in November. Thanks, buddy. Take care. Bye-bye.